Hello all. Myself Dr. Vanita agarwal. I have done company secretary, masters in law, UGC NET and PhD in Insolvency and Bankruptcy Code to 2016. Today I'll be going to discuss about Insolvency and Bankruptcy Code 2016, its timeline, its need, objective, outcome, how it's beneficial in India. This code has a different beauty in itself, in the sense it has given supremacy of powers in the hands of Committee of Creditors, while in earlier Companies Act or earlier insolvency laws, this supremacy was enjoyed by the promoters or management of the company. But this code has recognized the need of supremacy in the hands of COC, financial creditors. Different terminology, different concepts has been covered by this code in a very detailed and depth manner. And after having due consideration for each and every concept, this code has been notified. A welcome move by the Indian government, I can say. This is a centralized act applicable all over India. Now, considering its need for IBC in India, why this is required? Simple reason, the existing mechanism proves to be inadequate, ineffective. There was no centralized law dealing with insolvency cases in India. Most of these acts, SARFAESI, Provincial Act, Presidency Act, they were overlapping their jurisdiction. It was carried out in a very slow pace, maybe minimum 5 years. That's really painful for a financial distress, a sick company to carry on itself for bare minimum 5 years to get a good exit option. To get an exit option, that financial distress sick company need to wait minimum 5 years before High Court, which may run over for 10 years or maybe for 15 years. Very painful thing. Even after 5 years and 10 years, the recovery rate used to be very less. Hardly anything could be recovered by the creditors from this sick financial distress company. More and more number of NPAs were declared in banks. The cost involved for insolvency used to be quite high, which was not possible for a financial distress sick company to bear that cost, maybe of insolvency also. There were no option of ease of doing business. Also, no good option for EMIs given to banks. So we find that old disease and new prescription. The disease is same as that of insolvency, but the prescription is new code IBC. Why this is required? Obviously, to promote entrepreneurship. It improves credit availability for the sick company. As this code prescribes the timeline within which the CIRP process should be completed, so definitely it avoids prolonging time for a distressed company. This code is beneficial in the interest of all stakeholders. This code has minimized the role of adjudicating authorities, NCLT and CLAT. And the more and more supremacy is given by this code in the hands of COC, financial creditors. This code has come up with less of compliance mechanism. It avoids complications. It avoids combination. So this code is a boon for the Indian industry. Let's understand the timeline of this code, the journey it has come through. 21st of December, this bill was introduced in Lok Sabha. On 23rd of December, this bill it was referred to the joint committee of both the houses of parliament. 28th of April, this bill it was placed before both the houses of parliament. 5th of May 2016, it was passed by Lok Sabha, while 11th May it was passed by Rajya Sabha. Finally, on 28th of May, it received the assent of President of India and finally got notified. Let's understand applicability of this code. So any company which is incorporated under the Companies Act, this code is applicable to it. Any other companies which are governed by special acts, any LLP incorporated under the LLP Act 2008, any other body which has been notified by central government to be applicable for IBC 2016, partnership firms and individuals are covered under this IBC 2016. So these all are the ones for whom this act is applicable. Let's understand objects of this code. What is the main object of this code? The first and foremost object is creditor in control regime. Repeatedly I am specifying that COC, Committee of Creditors, comprised of financial creditors, and they are the supreme authority under this code. This code consolidates all the existing insolvency laws, and it also amends other laws wherever the amendment is required. This code has been given overriding effect over all other laws. This code covers the process in a time-bound manner, and it gives a good viable option to the companies which are undergoing CIRP. This code has given good waterfall mechanism in which the preferential payments have been made to the insolvency cost and the companies, and government taxes are not in the priority ranking. This code has covered a good investigation process in case there is illegal transfer of funds, diversion of funds or assets of the company. This code has established a supreme authority in the name of IBBI to administer and govern the insolvency and bankruptcy laws in India. These are some basic terms involved in this code, that's creditor, debtor, insolvency, bankruptcy, winding up, liquidation and dissolution. Who can invoke the provisions of IBC? First and foremost is financial creditor under section 7 of IBC. Any person to whom a financial debt is owed, banks and financial institutions. The next person is operational creditor under section 9. He can also invoke these provisions. And then the corporate debtor himself under voluntary liquidation scheme as per section 10. Let's understand the default amount. So in case of companies and LLP, this code has specified minimum amount of 1 lakh default, and for partnerships and individual the minimum default amount is 1000 rupees, just 1000, which can be increased in case of company to 1 crore and in case of partnership and individuals to 1 lakh by CG, and CG has increased this limit during COVID period. Whenever a company or LLP commits any default in paying its financial debt or maybe operational debt, then such company can file an application for CIRP before the adjudicating authority NCLT. Let's understand the timeline of CIRP. CIRP is to be completed in all 180 days. You can easily see on this timeline that the complete process of CIRP is completed in 180 days. That is with initiation of liquidation. So this is the timeline we have. Filing of application before NCLT, 14 days. Admission of application, then moratorium is declared. In the next 14 days, NCLT appoints interim resolution professional. Then public announcement is being made. 2 registered valuers are appointed to calculate the liquidation value. If the application is not been accepted or the company is not going for CIRP. So once registered valuers are appointed to find out the liquidation value, creditors need to submit their claim. Then first COC meeting is held. Information memorandum is being prepared. COC approves the resolution plan. And finally, it may lead to initiation of liquidation. Coming to the next concept, adjudicating authority. Let's understand what does it mean about adjudicating authority. Adjudicating authority here means NCLT, and its appeal goes before NCLAT. In case of partnership and individuals, the adjudicating authority is DRT, which appeal goes before DRAT. Adjudicating authority may accept the application or it may reject the application. It will accept the application within 14 days of receiving it if it's complete in all its forms. AA may reject the application if it's incomplete or default not occurred. Definitely before rejecting the application, AA issues notice to the applicant to rectify its defect, and it gives 7 days time to the applicant to rectify its defect. We can see the timeline here, 180 days. Maximum more 90 days are given, which makes in all 270 days. Fast track process, the timeline is exactly half. So adjudicating authority, after admitting the application, it shall declare a moratorium period, makes a public announcement, and appoints an interim resolution professional. What is moratorium? What is the effect of moratorium? We find that AA shall by order prohibit the initiation or filing any legal suit, maybe for executing any decree order against the company, which is prohibited during moratorium period. Company is prohibited from transferring any of its assets, legal rights, beneficial interest. Also, the company is being prohibited for any action to be taken as foreclosure or recover any security interest under SARFAESI. AA also prohibits the recovery of any property by the owner where such property is occupied by the corporate debtor. So we understand moratorium effect. What is this objective? The objective is to maximize the value of the company so that it can continue its operations. No additional stress should be given to business so that company can smoothly pay attention to its business, ignoring the adjudication, legal suits implication, and can comfortably run its business for its revival. So moratorium period has been specified under section 14 of this act. We all know that public announcement is being made wherein the details of the corporate debtor has been specified, and also the registrar with which the corporate debtor is registered with. Also, the public announcement specifies the date of the claim, last date by which all the claims should be submitted by the creditors or any other stakeholder. And this public announcement would specify about the penalties for any false claims. Let's understand the concept of interim resolution professional. He has been appointed by AA within 14 days of accepting or admitting the application. He is appointed for maximum 30 days from the date of appointment. Interim resolution professional, once he is appointed, then he takes care of all the management of the company. Board of directors powers are vested with him. All managers, all office staff reports directly to IRP. Financial institutions maintaining any accounts of corporate debtor, they need to follow the instructions of IRP. Then the next concept here is resolution professional. So after appointment of interim resolution professional, COC appoints a resolution professional, and this resolution professional takes the place of interim resolution professional, and he conducts the complete process of the company. Then we have duties of resolution professional. Under these duties of resolution professional, it clearly specifies here, calls for all the meetings. He presents all resolution plans at the meeting, maintain an updated list of claims, prepare the information memorandum, take immediate custody and control of all the assets of the company, replacement of resolution professional. COC to replace the resolution professional during the pendency of IRP. COC can also forward name of another insolvency professional to adjudicating authority, and then adjudicating authority shall forward the name of proposed RP to the board, to IBBI for its confirmation. So once this IBBI confirms, then this person is appointed as RP. Here we understand that committee of creditors. The IRP, he shall collate all the claims and determine financial position. He shall constitute a committee of creditors comprising of all financial creditors, we all know that, and it requires minimum 75% voting. Committee of creditors I have already explained, it is comprised of financial creditors. If there are no financial creditors, then operational creditors may be considered, having 10% of the total value of claims. Finally, a resolution plan is being prepared and presented before AA. Generally, AA does not interfere with the plan which has been approved by COC and other stakeholders, and also by RP. So if they all agree with this plan, generally AA also confirms the plan. Waterfall mechanism, a beautiful mechanism under this IBC. First and foremost expense which would be covered is the insolvency cost, and then for secured creditors, then wages, and then comes the unsecured creditor, finally workmen dues, and then crown debts, then any other remaining debts, then preferential shareholders, and finally equity. So these are some new institutions established, that's IBBI. Insolvency professional agencies, which creates IRPs, information utility, which stores all the data about these corporate debtors. So they are the strong pillars of this code. These are the benefits. And we have also seen some challenges covered under this act. So there are some also challenges under this act. You can see this. Government dues after unsecured creditors, right? What are professional avenue for resolution professional? So these are the works or the duties or the professionally he can be involved with these works. You can see here. Now again, I'll just highlight some of the landmark judgments covered under this code. Lokhandwala Kataria Construction, Innovative Industries Limited. Mobilox, very good important judgment. Mobilox Innovation Private Limited. The concept of dispute was discussed here. This is about overview of IBC amendments. I've covered some acts, some judgments considering the amendments. These are some judgments we discussed about the Limitation Act provisions. Whether this Limitation Act is applicable to tribunals. It was covered under this MP Steel Corporation case. Home buyers, very important point. They are covered as financial creditors. So now they are part of COC. A major chunk of finance come from home buyers for a construction company. So they are being given the status of financial creditors. These are some of the amendments I've discussed here. Alpha and Omega, that's about guarantors under IBC. So guarantors will not get the moratorium benefit. Moratorium is absolutely for corporate debtor and it is not applicable to any guarantor or surety. So this is the concept covered under Alpha and Omega, discussing about guarantors. This is what something about promoters under IBC. 29A has come out with some amendments for promoters definition considering these 4 layers I've covered here. Synergies Dure financial creditors. This is what something summarized with this case I've covered in this form. This is all about synergies. These are again some of the judgments I've covered here, discussing about 29A. And finally, there are some recommendations by the Insolvency Law Committee about MSME, its promoters, and yes, PPIRP concept has also been brought in by this code, that is pre-packed insolvency resolution profession, and accordingly, MSME has also been covered under PPIRP for minimum 10 lakhs amount. So this is all about my presentation. Thank you all.